Employment status, what's it all about? What does it mean for you as a small business owner? So the overview that I'm going to give in this session is aimed at small businesses. There's a lot more that we could say, and we could take a lot longer to delve into some of the legalities and the legal tests around law, employment status, and the rights and protections for different people working in businesses. We won't have time for that today, but this will be an overview, and hopefully it'll help you think about some of the practical risks for you, for your business, or maybe others that you know. So the backdrop here then is a complex picture has grown up, has evolved due to the developments of the gig economy in the last sort of 20-25 years. A lot of that and the new ways of working is due to the rise in technology. It's driven by technology, enabling people to work in different ways, in different places, and for different employers. We're going to cover today an overview of the different employment statuses and what they each mean, and how legal tests can be and are sometimes applied to establish what status people have. And we're going to think about what's in a name. How does employment status and the law on it relate to different job roles that you might hire for your business? And then I'll give you some useful resources at the end. And then, as I said, we'll allow a little bit of time for Q&A. So I'm going to go on to my next slide, which is an overview of employment status. And it's very simple, really, at its heart. There are only three statuses that are recognised in law as far as employment rights are concerned, and you see them on the screen: employee, worker, and self-employed. Now, we have a little bit of a confusing picture in the UK, because employment law rights are a different set of law to tax law. So when we think about taxation of earnings through employment, through work, there are only two categories that the tax laws recognise, and those are employee and self-employed. There's no middle ground in tax law. You can't be taxed as a worker on your earnings in the UK. You're either taxed as an employee or a self-employed person. Now, this hybrid ground in the middle of worker status was introduced some years ago to give some basic rights and protections to people who were working in the gig economy, who were dependent on large employers who were making use of different ways of working to perhaps give reduced benefits, reduced pay, reduced protections for people working more flexibly. So it's been introduced to stop the abuse of arrangements that are badged as self-employment, but in reality look more like employment. But in doing so, the government and our system of statutory rights has led to quite a confusing and sometimes muddled picture where even large employers get it wrong. So if we think about these three different statuses and what they mean legally, an employee works under what is called a contract of employment. It used to be known as a contract of service. We used to think of the situation being as a relationship of master and servant. That has moved on now, but we talk about a contract of employment, which is a contract between employer and or employee. It can be written down, it can be verbal, doesn't have to be on a piece of paper. It can be interpreted by circumstances and custom and practice if there's any uncertainty or dispute. Now, employees have the widest range of statutory rights, so rights that exist outside of what they might put in writing with their employer, basics around what they're going to get paid, the hours they're going to get work. Beyond that, there's a whole raft of statutory rights and protections, and for employees they are the gold standard, because they include the right not to be unfairly dismissed and the right to receive a redundancy payment if their role becomes redundant. They also include other rights like paid family leave, maternity, paternity, parental right, adoption, that kind of thing. The right to be paid if they're off sick, the right to ask for flexible working, and emergency time off. There are other statutory rights that sit alongside those, but those are the main ones when we think about employees. Now, a worker, on the other hand, is somebody who works under, can be an employee, so all employees are workers, because workers are people who work under either a contract of employment, so that's employees, or, and this is the important bit, any other contract where they do work personally and they're not holding themselves out or operating as a business providing services to a client. So we can all think very simply of businesses that provide services to clients, people like bookkeepers, marketing consultants, branding experts, business coaches. They're operating as private businesses, and the businesses they sell their services to are their clients. Workers are not in that category. They're people who don't manage their own businesses, but they work personally and sometimes look like employees. Their arrangements with the business they work for may be slightly different and more flexible, but they do have a set of statutory rights that are more limited than employees, but they are similar in some ways. So, for example, both employees and workers have the right to minimum pay, a paid holiday, and limits on working time. One key difference between an employee and a worker is that an employee would have the right to receive statutory minimum notice of the end of their employment, whereas a worker would not. So there are some key differences in the statutory frameworks for workers and employees. But if you were to look at a list of, like a checklist of right by side, they would look very similar in terms of the protections around hours worked and the pay that they receive. Now, the self-employed, as I said earlier, they operate their own businesses. They provide services to clients. They don't work under a contract of service, a contract of employment. They'd have a commercial agreement. It might be known as a freelancer agreement, or simply to provide their services. They choose their own work, who they work for and when. Often it's can be a one-man or one-woman band, their own boss. They have no employment rights, no statutory protections, except protection from discrimination, which of course applies to all members of the public, like self-employed people. Now, the key differences legally between these three categories of people that might work for or in your business are the following. For an employee, a true contract of employment as its bare minimum, there must be mutuality of obligation. That's a key legal term. So we mostly think of the mutual obligation being an employee agrees to work for a certain number of hours per week, per month, and the employer agrees to pay them for those hours. More widely than that, we can think about benefits and other things that are made available to employees, but at the heart of it, it's about the work wage bargain. Beyond that, for an employment relationship to exist, there must be control over what the employee does and when. So what they're expected to deliver, timescales, the quality of the work, etc. As I said, the contract of employment can either be written down on a piece of paper, it can be verbally agreed, or it can be implied by circumstances or custom and practice. As a small business, you want to make sure that any employee that you hire has a written contract of employment where the terms are set out clearly. There is no room for uncertainty to develop in that relationship. So if terms of employment change over time, that's captured in writing, whether it's a new form of contract or an addendum or something in writing, an email or preferably a letter. But you don't want to let things creep so that you have a lack of control and a lack of understanding between the parties as to the terms of employment. Now, the worker legally is somebody who does, similarly to an employee, provides that personal service. They're not allowed to send somebody in their place, but there is there's missing from this relationship is the mutuality of obligation, and there is less control over what the worker does typically. So when we think about mutuality, it's, you know, I agree to work on certain days or certain hours, you pay me, Mr. Employer. For a worker, there'll be maybe no obligation to offer work and no obligation for the worker to accept work. So it's very much a flexible arrangement as needed from time to time, and it's less reliable for the employer. And the self-employed have a right to send substitutes, so they might have a team of people or partners, associates that they use as a resource, and they can use those people to provide the service to the client. It doesn't have to be the self-employed person personally. They organise their own resources, they control when and how they work, and they take the financial risk, insurance and uncertainty of income. So recent cases in recent years have been quite high profile, and you may have heard of some of these cases in the news. The Uber case that reached all the way to the Supreme Court, where Uber drivers, taxi drivers, were using the Uber platform and operating ostensibly as self-employed people, and accepting assignments, if you like, picking up customers as and when they signed into the platform. They were free to work for other platforms, but they decided to assert worker status because of the terms of that arrangement and the way in which they were controlled, if you like, by the way that the Uber platform worked, and the limitations on their freedoms when they were working during each different assignment. So that's gone all the way to the Supreme Court, who decided that Uber self-employed drivers are in fact workers. So you can see how these things can, in extreme cases, be very important, very costly, and lead to decisions that are a bit unexpected, so that people that you thought you didn't owe holiday pay to or national minimum wage could ultimately be decided by the courts to be that your responsibility and cost you not insignificant amounts of money if it involves multiple people. Other cases like Pimlico Plumbers and AutoCleanse have dealt with all the same issues, people looking like the self-employed but who've asserted either employment status or worker status to get extended statutory rights. So I'm going to move on to the next slide, just to give us a little flowchart at a glance to show us how we might navigate through this complex web. So first thing to ask yourself is, does the individual work, or the individual that you're going to hire, are they going to work under a contract of employment? Are some of these elements going to be present? And if you haven't got people working for you already, but you are thinking of hiring, what is it that you need for your business? Do you need ad hoc, flexible resource from time to time, but you don't want the liability and the cost of employing somebody for the longer term? If so, a worker contract could be the way to do it. And we'll come on to some of the labels that you might give that person in terms of a job role. So does the individual work, or are they going to work under a contract of employment? Are they going to be part of your stable workforce? Are they going to grow with you in the longer term, or at least be there for a fairly fixed amount of time working for you regularly? If the answer is yes, they are, or they need to be, your employee. So you need to have a contract of employment that is labelled as such, and that upholds, that doesn't take away from some of these minimum statutory rights. If the answer is no, they're not going to work under a contract of employment. That mutuality of obligation is not going to be there. The control isn't going to be there. They're not going to show up work regularly and be expected to work minimum hours and be under your supervision and be integrated into a team. Then a worker contract is probably the way to go. And then, so that we're then going on to the question of, well, are you going to be controlling when and where the work is done? If the answer is no, then they probably do they look like they own their own their own business and take financial risks? Are they providing their own tools? Can they send substitutes? And then they're looking like a self-employed person. If you are controlling how, when and where the work is done, if the answer to that is yes, then we ask, are they carrying out the work personally? Are they allowed to send somebody in their place? If not, then they're looking like a worker. So in summary, employees, we usually think of as fixed term, part-time. They can be part year, or they can work more casually, but they usually work under a contract that gives relative certainty over when they will work and what they will get paid. They are usually integrated into a team. Their work is supervised and controlled to some extent, and they would be paid through PAYE. Workers, on the other hand, would be a more casual resource. The usual label that we hear a lot about is 0 hours. There'll be some limitations imposed on 0 hours contracts coming down the line in the Employment Rights Bill. I'll come on to that in a little while. But safe to say that those contracts are probably not going to be user-friendly for businesses in the longer term. So you might need to think about badging people differently once that happens. Workers will be used for short-term work, peaks and troughs, maybe projects, maybe a flexible resource to reflect seasonal demand in your business. They might have a limited right of substitution, and they will be paid through PAYE. One important thing to understand if you're going down an employment model for growing your team is that for employees, there are implied duties at common law. So these aren't statutory rights, but they are more, what shall we call them, ethereal. You know, they're rights that sit there, but they're not, you know, you can't go to a particular piece of legislation and say, oh yes, I see it there. They've grown up through case law, but the most important one that's often at play, if you like, between employers and employees is that of trust and confidence. So we look at decisions around disciplining employees, managing absence, managing performance, and then ultimately terminating the relationship, dismissal. That duty of trust and confidence comes into play. It's often the way by which, or the measure by which, decisions, if they're disputed in an employment tribunal, are judged, particularly when claims for unfair dismissal are brought, or constructive dismissal where the employee leaves in the face of treatment that they didn't like, and claims that they've in effect been dismissed through the employer's conduct. It also comes into play when we think about conduct of employees in relation to keeping confidential the secrets of the business, the trade secrets, or the confidential business proprietary information that is of value, and when we think about creating intellectual property. So those are things that you need to be mindful of, because they need to be built into your contracts of employment. They look like, for example, confidentiality clauses, maybe restrictive covenants around what the employee can do and not do after they've left your employment. And typically you think about using those clauses to protect your business assets, your business value, as well as having intellectual property clauses in there to make sure that the employee understands that what they produce during the course of their employment is owned by you. One thing I want to pick up on at this point is just to say, I mentioned tax earlier on and the different position under tax law. The self-employed or people that you badge as workers can have deemed employment status for tax. This usually happens where a self-employed person works through an intermediary, maybe their own personal service company or another intermediary, and you have to make an assessment of their tax status, whether they are in fact a self-employed person for taxation of earnings, or whether their day-to-day, the way they work for you, even though they're called self-employed and they might invoice, whether that activity is what we call deemed employment. There are various HMRC tools that businesses have to use. The client, if they're in the public sector or they're a large employer, has to make that assessment. If you're a small employer, it will be down to the intermediary to make the assessment. If somebody comes to you to work through an intermediary company, badged as self-employment, and if they're only working for you, that's a red flag, and you will want to be alive to that and understand whose obligation this is and what it means for you and your business. And the other risk to flag at this point is this risk of workers or the self-employed asserting employment status if they work regularly as part of your business, and as I said earlier, if a worker's contract sort of creeps into an implied custom and practice employment type arrangement where there is more control, there's more expectation, there's more mutuality of obligation. You want to be alive to that risk by making sure you keep your contracts up to date. and they correctly reflect the reality of the working relationship. So that risk of asserting worker or employment status can come where you end the contractual arrangement with somebody who is badged as self-employed. They don't like that decision. They decide to bring a claim for unfair dismissal or maybe discrimination against you, and they do so by saying, well, actually, I was an employee, even though my contract said something different. I'm going to go on to my next slide, please, Hermon. So, what is in a name? We have all of these different words bandied around, and we use them fairly casually in terms of labelling people who come to work in a business. And they are important. They're not the whole picture, however. What I've done is to just throw up a few of these words on the screen because some of these words, casuals, consultants, freelancers, contractors, tend to be used to describe people who are self-employed, who we think are genuinely self-employed, who provide services for our business. But thinking about what we've just learned about workers, we can see that casuals could in fact, even though they say they're self-employed and they invoice, could actually fall into this worker category. And if they do, then it's your responsibility as an employer to pay them through PAYE. Now, in reality, people choose self-employment because it is tax advantageous, it may be tax efficient for them. It's also advantageous for your business because it costs you less. You don't have the cost of holiday pay and you don't have the cost of employers' national insurance contributions, but you need to understand the risk. And if there's any, the red flag that we described earlier of a person coming to work for you through an intermediary, a limited company, then you should be sure to make it clear that it's their responsibility to carry out that assessment of tax status to check whether they have deemed employment status for their earnings and taxation of their earnings. And if they don't like that, then I'm afraid there's probably that's probably a flag to say that they are attempting to dodge their tax liability. So they're probably not a safe bet for you to take on, even though they may bring very good skills to your business and expertise that you need. They're bringing a tax risk to you. So think about the badge that you give them carefully, but also think about the contractual arrangements. If these people genuinely are self-employed, then they need either a self-employed agreement that they give to you, or you will need to create your own terms for freelancers and consultants. Either way, you need to check the terms carefully and that they match the reality of the relationship. So other people like part-time, fixed term and casuals again could indicate either an employment relationship or a worker status relationship, and you need to be careful how you badge that in the contract and make sure that it correctly reflects your expectations. And then people such as interns and volunteers are in a slightly different category, and I'm just going to touch on these because as a small business we take on interns, and it's often seen to be a way that businesses who are strapped for cash, who can't afford employment costs, can grow internally and maybe recruit. It's a good recruitment model to take an intern, and if that relationship works out in the longer term, then you go to employment when you can afford to. In the past, internships were unpaid, and they were seen to be of more value to the intern than to the business. Things have changed, and there is an expectation, certainly on universities, that any students they place with businesses for internships will be paid at national minimum wage. I would say that if you're employing an intern for a fixed period of time, you're expecting them to work. You want to have that control over what they do, when they do it, how they do it. You want to train them. You're looking at them as a longer term hire. Then you would enter into a contract of employment with them, and that might be on a fixed term basis for a short term initially, and then you might have a succession of fixed term contracts as you grow that relationship. But taking an unpaid intern for national minimum wage purposes is only allowed if it's part of a course where the internship, the placement, is less than a year long, less than 12 months. You need to be careful on national minimum wage. Volunteers, on the other hand, are people who are free to come and go. There should be no obligation on them to turn up at particular times. You would not want that to be badged as a worker agreement or as an employment contract, but you could have a volunteer agreement, something in writing, just to set out expectations, to make it clear that they're not under a contract of employment or any kind of contract with the business at all, and making them making clear what the sort of code of conduct, the expectations as to behaviours, values of your business, etc. But volunteering, unpaid, but you can pay expenses, and you would be expected to pay volunteer expenses, but not for time worked. And then finally, directors are a category all of their own. Directors, company house directors are, strictly speaking, officers of the company. They're not employees automatically. Most owner-managed businesses are managed by directors of the business, and if they work in the business from day to day, they carry out executive functions, then they will be employees. They may or may not have a contract of employment. It's usually called a service agreement for director, and that service agreement should, if there is one, reflect the statutory duties on them as a director, and it should be tied to their office, the officer role of director. But many people are employed as directors in business who are not statutory directors. If their director name is in name only, then they would be expected to have a contract of employment, because they're employed by the business, they're paid by the business to carry out a specific role, for example, HR director, marketing director, etc. Next slide, please, Hamon. So I have a few useful resources for you here that you might want to look at as small businesses. ACAS is useful for many, many different things. It will have guidance on worker and employment status. It will also have guidance on contracts of employment and on things like minimum wage. The next resource is very useful, and it's from gov.uk, and it's a very simple and easy to access guide on employment status and some of the things that I've overviewed for you today. It'll also drill down into the different statutory rights that apply to both workers and employees. And there's another link to gov.uk, which is a more high-level view of employment status there. And lastly, following the webinar today, I'm going to send you our free employment status guide that you can have a read through at your leisure, and hopefully it'll add a little bit more to what I've been saying in the last 25 minutes. And so I'm going to stop the recording now. Apologies that I've gone over a little bit of time, but if anybody has any questions now, I'll be very happy to try and answer them.